I'm rejecting the plea agreement. I'm resetting your case for 3 weeks. We'll see you back in 3 weeks. Y'all can talk about it then. You're at, ma'am?
What?
This is not going to help.
What you're about to watch is not just a routine courtroom hearing. It's a slow-motion legal meltdown. A defendant with a massive criminal history walks into court expecting probation. A judge who starts off calm but clearly uneasy. And a plea deal that completely unravels in real time. As the minutes pass, contradictions surface, patience wears thin, and what begins as a chance at leniency turns into a cautionary tale about attitude, accountability, and courtroom decorum. The real question is, at what exact moment did this all go wrong? And could it have been avoided? Watch closely because every word matters in this courtroom.
You're just going to make it worse. You should, when I told you a minute ago to stop, you should have stopped when I told you to. Let's see, can you... All right, I'm going to set your bond at $25,000. Go back with the bailiff. Morning. Are you Crystal Bogan? And Ms. Bogan was previously in court, entered a plea of guilty to theft of property, a state jail felony. That agreement was for a 4-year deferred probation with a $1,000 fine as well as restitution in the amount of $9,400. I've received the pre-sentence report. Have y'all all had an opportunity to review that report?
Yes, the report on the restitution, most of the main issue we're looking at, get some of that money back.
I've got 1, 2, 3 and a quarter pages of criminal history.
This is the first major red flag in the hearing. The judge isn't just reacting to one mistake. She's staring at a pattern. 14 felonies, multiple misdemeanors, and several cases that weren't dismissed tell the court one thing loud and clear. This isn't an isolated lapse in judgment. Judges are trained to look for rehabilitation potential. But when they see repeated financial crimes, forgery, and theft across multiple states, skepticism naturally sets in. At this point, the tone of the hearing subtly shifts. The court is no longer just reviewing a plea deal. It's evaluating whether this defendant can realistically comply with probation at all.
Well, there's a lot of stuff that wasn't dismissed. There were 14 felonies that weren't dismissed. At least 4 or 5 misdemeanors that weren't dismissed. I understand the restitution, and y'all know my position on that already this morning, but she's on probation right now in Sutton County, correct?
Yes.
I have been for 2 years.
Right. So do they know about this case? And what has happened over there, if anything?
It's harder than it might seem. When the judge questions whether nursing school is realistic with this criminal history, it's not meant as an insult. It's a reality check. Certain professions, especially healthcare, involve licensing boards that conduct deep background checks. Theft, fraud, and forgery convictions can permanently bar someone from certification. The judge is essentially asking, is this plan grounded in reality, or is it wishful thinking? It's a tough question, but one courts often raise when defendants present future goals that may not align with their legal record.
There, if anything.
I'm still continuing on my degree. Because I'm actually supposed to start nursing.
I can't understand you.
I'm supposed to start nursing school.
When?
I was actually supposed to start in September, but I had to wait to see.
Are you really going to be able to go to nursing
Yes, I
school
am.
with this type of criminal history?
Yes, ma'am. Because I haven't been convicted of it. I'm a CNA now.
Where do you live now?
In Houston.
$2,400, but then it also, that was from inside the bank, and then it shows $500 from an ATM and $100 from a cash app, totaling $10,000, not $9,400. Is that correct?
And that would have been added on, Your Honor, that's a bank fee, I believe. I don't think that.
Well, it says 500 was withdrawn from an ATM outside the bank. Is that right? You know better than anybody.
I only went into it. I didn't have no access to the card or nothing.
Okay. So possibly the other person that was involved did that?
The only thing we knew about
That was
$9,400 that was in the bank.
I wasn't aware of it, Your Honor, when we did it, when I got the PSIs, I was notified of the files.
Here's where legal responsibility becomes crystal clear. It doesn't matter who physically withdrew the money. Under the law, joint participation means joint liability. When crimes involve multiple people acting together, courts don't split blame based on who touched the ATM or made the transfer. If you're part of the scheme, you're responsible for the full loss. That's why the judge shuts down any confusion about amounts or methods. From the court's perspective, the victim is owed restitution, and internal disputes between co-defendants don't reduce that.
In the cash wrap. But if it was a withdrawal, then that would be her responsibility joint and separately, so
Right, it says, so
that's a request.
the contact from Do Good said that the defendant withdrew the entire loan amount of $10,000, 94 from inside the bank, 500 from an ATM, and 100 from a cash app transaction. It doesn't matter if you did it or if the other person that you were with did it. Y'all were working together. So you're both, and what's the other status of the?
I don't have the other status of another person, Your Honor, this is one that's the charge. I'm not posting on there. But she's responsible.
Yeah. So I mean, if there was another person and you didn't give that information, then that's, okay. Apparently the cops didn't either, so.
She went in the bank, she was the one called size, whether or not she had the backside, is not to my knowledge.
And hold on, so the probations in Sutton County, have they been transferred to Harris County? So you're going in person in Harris County?
Yes, ma'am.
Okay, and so it's the state's position to go forward with the agreement?
I understand the court's concern, and the state has the same. Like I said, our initial deal was to get some of the money back on our victim, however, we understand.
So, all right, so here's what I'm going to do, Ms. Bogan. I'm going to find that you entered your plea of guilty freely and voluntarily. Can y'all hold it down over there, please? I'm going to find that you entered your plea of guilty freely and voluntarily, find sufficient evidence to find you guilty.
This is the turning point. Judges are not required to accept plea agreements, and when they reject one, it usually means the deal no longer fits the facts in front of them. With 14 prior felony offenses involving similar conduct, straight probation begins to look unreasonable in the court's eyes. The judge is weighing public safety, accountability, and credibility. Once she verbalizes doubt, the outcome becomes increasingly predictable. At this stage, the defendant's demeanor and responses matter just as much as the paperwork.
I just don't know. I just can't believe I'm even considering doing this, honestly. I'm not. I can't. There's no way. It has to be straight probation, and I realize that that's going to potentially have some issues, but I can't with 14 prior felony offenses, same type of thing, so.
I don't.
You do?
No, I don't. No, I don't.
Okay. How many do you think you have?
I have 3 hearings and one back home.
Okay, you have lots of them that were at the same time for different offenses.
And I was never convicted, never charged.
Yeah, you did probations for them. Forgery of a financial instrument. March, don't talk over me. March 3rd, 2008, Harris County, 180 days in jail, so that one was reduced. March of 2014, forging identification cards in Cuyahoga County, Ohio, 1 year probation. Same charge, same probation, so that's 2 in Ohio. March of 2014, theft, aggravated theft in Ohio, another probation, the same date, but still another charge. March of 2014, attempted drug possession, pled guilty, 1 year probation. March of 2014, same thing in Ohio, possessing criminal tools, probation, all that. It was at the same time, but still different cases. November of 2014, forgery, 2 cases, got probations in those. I'm gonna run out of fingers. March, another one, theft, aggravated theft in Ohio in 2014. Then we go to Sutton County, Texas, and you have 1, 2, 3, 4, 5 continuous smuggling of persons for pecuniary benefit, and that's the 10-year probation that you're on in 5 different cases.
Okay.
That's not correct.
No. Okay.
So how many cases are you on probation for in Sutton County?
It all ran together.
I understand it all.
It's one.
It doesn't run.
This is where everything collapses. Courts expect composure, especially when someone is asking for leniency. Cursing, storming out, or disrespecting counsel signals a lack of impulse control, and judges take that very seriously. Bond decisions are based on risk of flight, risk of reoffending, and risk of noncompliance. When the judge raises the bond, she's responding not just to criminal history, but to what she's seeing live in the courtroom. This moment transforms a legal
It doesn't run, but that's not how it works.
Yes, ma'am. Yes, ma'am.
When it runs together, it just means you're serving it at this. I'm rejecting the plea agreement. I'm resetting your case for 3 weeks. We'll see you back in 3 weeks. Y'all can talk about it then. You're at, ma'am,
What?
this is not gonna help.
It don't matter. My life's on anyway.
Well, looks like you did that, not me. I'll see you in 3 weeks.
It was at this moment that she knew. She fucked up.
Come on, hold on, get her, don't let her go. Come back.
I heard bullshit.
Everybody heard it.
You're bullshit.
Come back.
You're a lawyer.
I told my lawyer he was bullshit. I didn't say this.
You don't talk like that to anybody in this case because he didn't do this either, you did.
He got me the plea.
He did get you, he did a great job. I'm gonna find at this time that your bond is not sufficient because of your attitude and because of your criminal, because of your,
I gotta go to work. So I'm gonna lose my job and everything too?
Well, maybe you shouldn't cuss at your lawyer, maybe you shouldn't have this attitude here in the courtroom. I'm going to raise your bond. What's the bond currently set at?
This case is a powerful reminder that courtroom outcomes aren't decided on paperwork alone. Criminal history, honesty, accountability, and, most importantly, behavior in front of the judge all shape the final result. What began as a plea deal with probation unraveled due to a pattern of past offenses and a breakdown in courtroom conduct, ultimately leading to a rejected agreement and increased bond. The lesson here is simple. Respect the process, understand the stakes, and never underestimate how much your attitude can influence a judge's decisions. Backhand index pointing right if you found this case as shocking as we did. Hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.